start. I was just putting it recording, so I wanted to make sure that we can send a recorded version of this as well. So good afternoon to those who are in the Eastern, Central, and Mountain time zones, and a very good morning to those in the Pacific time zone, including those in Alaska and in Hawaii. Thank you very much for taking an hour from your busy schedule and joining our webinar today. My name is Giarratani Sinha. I am the founder of JOBfindah Network and the moderator for today's webinar. I'll make the introduction and, time permitting, take questions and pass them to our guest speaker. Today's webinar is hosted by JOBfindah Network. Shafeeqa, if we can move to the next slide. I think you are controlling. Businesses across the country, they use JOBfindah for easy-to-use job posting, distribution, marketing, and technology solutions to power their diversity recruiting, as well as federal contractor OFCCP compliance, and in many occasions, customized solutions to enhance their recruiting performance. Online recruitment and compliance are dynamic fields, and the industry is evolving at a faster pace than ever before. Learning and community discussion is important. So today's webinar is not a sales pitch of any product or solution. Instead, it is going to be an extremely informative discussion focused on learning. Our topic is a timely one: new directives, transparency, and collaboration, how to prepare for OFCCP compliance reviews in 2019. As you know, just in the last few days, the OFCCP introduced 3 new directives, making it a total of 12 new directives in 2018 alone. Everyone is interested to know how these changes will possibly impact their employee attraction and retention strategies, and how the agency might examine compensation, affirmation action, and recruitment practices in OFCCP compliance audits. There is a lot to learn and a lot more of new information to process. So I'm particularly thankful to our speaker, Shafeeqa Giarratani, a respected attorney and managing partner of the Austin office at Ogletree Deakins. Shafeeqa is a leading authority in our industry and a very much sought after speaker. She represents employers in federal and state courts and before administrative agencies and regulatory agencies such as the Equal Employment Opportunity Commission, the Texas Workforce Commission, and the Office of Federal Contract Compliance Programs. She regularly advises federal contractor clients on affirmative action, legislative and regulatory changes affecting employment matters, and OFCCP compliance issues, from developing affirmative action plans to representing companies during the audit process. Shafeeqa earned her JD with honors from the Harvard Law School. She also holds an AB degree with honors from the Harvard University. I'm truly honored to have Shafeeqa with us today. Finally, just on logistics, with remote communication such as this, there is always a possibility for someone getting disconnected. If so, please dial in again. Please stay with us even if we are disconnected momentarily. We'll make a copy of the presentation as well as recording of the event available after the webinar. And finally, one thing, please note that HRCI or SHRM credits are unfortunately not available for this webinar. We are working on this, starting our next one. But I'm sure that this is going to be very informative and useful for you. Once again, just finally, if you have a call-in problem, you please call in to the number that I gave before, 1-917-338-1451. Participant PIN is 129581 $. Now, without further ado, let me present Shafeeqa to you. It's all yours, Shafeeqa.
Thank you so much, Ratin, and thank you to JOBfindah for inviting me to speak today. As was mentioned, my name is Shafeeqa Giarratani, and I'm an attorney specializing in the affirmative action and OFCCP compliance area. I'm the office managing shareholder of the Austin, Texas office of Ogletree Deakins. One of the things that I have seen a little over this past year is we have had an extremely active time for federal contractors. We have had a record 12 new directives that have come out really just over a little over a year. I'll tell you all that I was at a conference about 6 weeks ago where the acting director of the OFCCP was speaking, and he confirmed that he, as the acting director, has published the most directives of any OFCCP director or acting director. So it really has been an active time, and if you feel like a lot has been happening and a record amount of items have been happening, it is absolutely true. Here's what I think is interesting about what Craig Lean said about why we've got all of these new directives. And he said that a lot of it has to do with his goal for the OFCCP of transparency. And what he is attempting to do with these directives is really publish and put out into the public how he wants the OFCCP to operate. And what he explained is that by putting out these directives, it allows the OFCCP to kind of have the rules of the road, and also federal contractors to have those same rules of the road, so that we're all on the same page about what we can expect in an audit, and so that there is full transparency about what the rules of the road are. So I think that that is a laudable goal, and that's what he says is behind these record amounts of new directives. So with that, before we jump into all of those new directives and what they mean for you all as federal contractors, a little bit of housekeeping. So the standard disclaimer, the information in this presentation is really provided for general information, educational purposes only. Although I am a lawyer, this presentation is not intended to provide legal advice to those of you that are on the phone today. Also, the materials that I'm presenting are copyrighted and cannot be reproduced or copied. They are the materials from the law firm of Ogletree Deakins. So with that out of the way, here's our agenda. We're first going to talk a little bit about some of the shakeup that's happened at the OFCCP and who is in charge now and some of the key faces that are there. We're also going to walk through that record amount of 12 new directives and really take you through what are some of the key provisions of those directives and some other developments that you should be aware of. Finally, and importantly, we're going to talk about what this means for you as a federal contractor, besides all of the heartburn of keeping up to date with all of these changes. At the end, there will be a little bit of time for questions. As was mentioned, we are on mute mode, so throughout the presentation, please feel free to type in your questions as we go. I'll try to answer them as we go, but remember there will be a bit of time at the end for questions. So let's start off a little bit with who is in charge at this time and what are some of the key personnel and leadership changes that have happened at the OFCCP. So as many of you all will be aware, the Office of Federal Contract Compliance Programs does enforce federal contractor obligations. So in short for that is OFCCP. Under our previous administration, Patricia Hsu led the OFCCP, and President Trump put Andre Harris as the current as the director of the OFCCP in December of 2017. However, Mr. Harris is no longer the directive. He resigned, and he's now in private practice in Washington, D.C. He had a fairly short term at the OFCCP as director, and quickly after him, named as the acting director in July 2018, was Craig Lean. Now, Craig Lean had previously been the number 2 under Andre Harris, so it was no big surprise that as the OFCCP was looking for someone to step in after Mr. Harris's resignation, it fell to Craig Lean, and he has been very active since, as I mentioned before, with these 12 new directives. A couple of other changes to be aware of. Marika Litras changed from the Director of Enforcement to the Acting Deputy Director, so a step up for her. Deborah Carr, a long-time veteran of the OFCCP, left the OFCCP to go to the Job Corps, so also causing some changes in how the OFCCP is run. We've also seen a couple of vacancies, specifically in the Pacific and Midwest. Our regional directors that were previously there are no longer there. What all of that means is really broad-scale changes and lots of shakeup at the OFCCP at the top levels of the organization. Something that came out during Patricia Shue's administration of the OFCCP was a GAO report. It was published in 2016, and in some respects it was a bit scathing of the OFCCP. And some of the things that came out was in that GAO report was a great deal of frustration from federal contractors. And that frustration came from how audits were being run. There were complaints about how long audits took, how long it took for the OFCCP and compliance officers to respond to requests being given, and also some complaints about the perceived unprofessional conduct by some compliance officers during audits, and some complained of overly aggressive behavior. So the OFCCP has conducted listening sessions, and as a result of those listening sessions, they have published a contractor's manifesto of what contractors can expect moving forward in their audits. And here are some of the key tenets of that what contractors can expect manifesto. The OFCCP has said that all contractors should have access to an accurate compliance assistance manual, that also they should be given timely responses to any type of compliance assistance question that they have. One of the keys also was opportunities to really collaborate with the OFCCP and provide meaningful feedback throughout the audit process on any questions that the OFCCP may have. Other key tenets of that manifesto is that the OFCCP compliance staff will conduct itself professionally, including neutral scheduling of compliance evaluations, and that there will be a reasonable opportunity throughout the audit to discuss whatever concerns a compliance officer or those working on the audit may have, and to provide explanations on those concerns before we get to the notice of violation or further down the road in enforcement. And finally, part of the manifesto was that there would be confidentiality of certain information handed over during an OFCCP audit. A big part of what we'll talk about today is that record number of 12 directives that have been published by the OFCCP. If you're looking to have a fun read for yourself, they are pretty easy to find. You just go on dol.gov/OFCCP/regs/compliance/directives, and there you will find all of them for your viewing pleasure if you want more detail about what specifically is in them. But here's a question. What is really an OFCCP directive, and what does it mean? Well, a directive does not change the law. Executive Order 11246, VEVRA, Section 503 of the Rehabilitation Act, all stand as they do, as well as all of the accompanying regulations. Directives also don't create any kind of legally enforceable rights or obligations. when we think of directives, what we can really understand them as is really the OFCCP, an agency providing guidance to contractors on what they can expect. And that really fits with what we've heard from Craig Lean, that the purpose is to provide transparency for everyone to know what they can expect, and that's really what these directives are used for. They can be rescinded and written pretty easily. They don't have to go through any type of comment period. In fact, what I have heard from Craig Lean himself is that he himself has drafted many of these on his own pen and paper. And so it's not a comment period, although certainly there is input that is taken from relevant stakeholders, I'm sure, as these directives are being written. Directives really just give us insight into what the OFCCP is focusing on and what their methodology will be in those enforcement efforts. So let's talk about the 12 directives. I've kind of broken them up here into those directives that came before Craig Lean was acting OFCCP director and those that came from him directly as acting director. And there were 2 before and then the rest after. So let's talk about those 2 before Craig Lean became the acting OFCCP director. The first one was 2018-1. You'll see that they are named for the year and then just numbered on through the year. And this one was published in March 2018. And it is on predetermination notices. And what this directive talks about is that during an audit that it will be now more standard operating procedure to issue a preliminary finding of discrimination, or a PDN. This will be issued through the regional solicitor, which is the lawyer's wing of the OFCCP, and the national office will both have to review that before it gets to a contractor. Now, what's the effect of having a PDN as more of standard operating procedure and requiring that the lawyer wing as well as the national office take a look at that before it ever gets to you? Well, the effect is oversight. Now, all of our local OFCCP offices are going to have to put together something compelling, which is going to be reviewed by the higher-ups before it gets to you. And I think part of this was really responding to some federal contractors' complaints that things were being issued out of local OFCCP offices, findings of violation that they felt were not really well-founded or supported by the evidence. This has a preliminary piece to it where there is some review. The other piece of this, I think, that we should know is now that these are going up and having several layers of review, they'll probably only be issued when the OFCCP truly believes that they have got a legally sound position. And so the PDN makes us know that this is serious, this has been reviewed from the top. I think another piece of this that is helpful for federal contractors is now you will have an opportunity to really rebut any type of coming notice of violation through the PDN. And it's important that if you get a PDN that you rebut this quickly because it is likely, since it has been reviewed in the upper levels of OFCCP, that a notice of violation will quickly follow. Now, there's really not a whole lot of difference between what the PDN looks like and the NOV. It really does provide layers of review and an opportunity to explain before you get that notice of violation. And I think it's a good idea to take advantage of that PDN process. Another thing to think about is it also provides an opportunity for an early settlement before you get to the notice of violation stage. That was the first directive that came in 2018. One more that was before Craig Lean became the acting OFCCP director, and that's Directive 2018-02, which was published in May 2018. Now, this one covers, for those federal contractors that are out there in the healthcare field, a moratorium. If you are in the healthcare field or have been watching closely this area, you'll remember that back in 2014, there were several cases going back and forth on whether if you had TRICARE, which is a certain type of insurance that extends to veterans, whether having that or using that as a federal contractor made you a federal contractor, whether simply providing TRICARE, reimbursements through TRICARE, et cetera, made you a federal contractor. And there was also an act that was passed through Congress which seemed to exempt companies from being subject to OFCCP jurisdiction simply through having TRICARE. After that act was signed into law, the OFCCP issued a 5-year moratorium on affirmative action enforcement based on TRICARE alone. Now that has been extended, that moratorium, even further into May 2021. And so that is the effect of 2018-02. Now it is important if you're a healthcare provider that has a contract with the Bureau of Prisons or NIH to really look deeply, because you may still have and probably do have obligations to comply with all affirmative action obligations, including preparations of affirmative action plans. Well, here's where the bulk of the directives come, and that is after Craig Lean was appointed OFCCP acting director. And so here are the rest of them, including a proposed directive which have been put into place since October 1st, 2018, with the most recent coming just a few weeks ago in November 2018. So let's walk through these and talk about what they'll mean for your organization. So Directive 03 out of 2018 was with regards to faith-based organizations. Now, what's in this directive is instructions to the OFCCP staff regarding the myriad of court cases out there discussing legal protections if the federal contractor happens to be a religious-based organization. Now, the directive is a bit vague in its nature, but what it simply says is that OFCCP staff must consider these legal developments, be aware of these legal developments when they're providing compliance assistance or when they are enforcing various OFCCP rules and regulations. Now, what does this really mean? And I will tell you all that I was actually presenting at this same conference where Craig Lean was speaking, and I presented on specifically this directive. And in that presentation, I had some questions, because I said this directive leaves open a lot of questions, like if you are a religiously based organization, of whom I represent quite a few, what does this mean for that executive order which says that you cannot discriminate based on sexual orientation or gender identity? Because interestingly, in this directive, there's no specific mention of the issue of that executive order prohibiting discrimination and what it means for religious-based discrimination or religious-based organizations. So it was interesting because after I asked these questions, Craig Lean stood up and said he would provide answers. And I guess he sort of did. What he said is that this directive was really meant for OFCCP staff to know that this is a complex area. So before issuing a PDN or a notice of violation on particular issues, it's important to consult up through the national office and through the solicitor's office. And he said that the law is murky on this, but he did say he was quite clear that the executive order prohibiting sexual orientation and gender identity discrimination stands, and he expects all federal contractors to abide by it. But he did say that there are different considerations that need to be taken into account, and this was kind of a caution sign for compliance officers before digging into this area. The next directive under Craig Lean is 2018-04, and it talks about focused reviews. And this is one that is kind of still in development. So what the OFCCP says in this directive is that there will be audits where they focus on only one of OFCCP's 3 laws. That could be Executive Order 11246, covering minorities and women. It could be Section 503 of the Rehabilitation Act, covering affirmative action towards individuals with disabilities, or it could be related to VEVRA, which protects veterans and provides affirmative action for covered veterans. The OFCCP says it's still developing FAQs and the complete procedure on how these reviews will progress. Now, one of the things we've heard about this is that what we will expect from these types of focused reviews is more of a focus on Section 503 and VEVRA, as opposed to Executive Order 11246, which often gets quite a bit of focus in really all OFCCP audits. But what we might see is a focused review that we're really going to focus on what are you doing in terms of your outreach for individuals with disabilities, or the same for veterans. I think we can expect that under this we'll see more of those types of reviews, but more information on that is still yet to come. The next one that we saw come out in 2018, number 5, was the compensation guidance and frequently asked questions. Now, what was this one all about? Well, we know, we've all heard in this federal contractor space that one of the things that the agency put renewed focus to was the issue of pay discrimination and pay gaps between men and women and various racial groups. And they've really spent lots of time on this issue over the past 5 to 10 years. I think one of the things that's been difficult in this area for contractors is really that we've been seeking really clear, unequivocal guidance for how the OFCCP would conduct their compensation reviews. Now, we know that what the OFCCP did is rescind the previous administration's directive for how it would conduct compensation audits and reviews. And so with this new directive, number 5 in 2018, we were so hoping that what we were going to get is something that would tell us exactly what the OFCCP would do moving forward. Unfortunately, that's not what happened. What this one does, this new compensation guidance, is really many things that are similar to what we had in the old guidance. It says that the OFCCP has enormous discretion and decision-making ability in choosing through each individual audit exactly how it's going to look at pay and the results. It says it can look at them in a way that will be different maybe than how it's done before, or the same. And it also allows really a great deal of leeway for the OFCCP and compliance officers to look at your data in all different types of ways, with the potential of finding some gap, some way to show discrimination. So let's dig in a little bit into this compensation guidance that was issued as the 5th directive in 2018. So it explains that there's really 2 types of pay cases. One, which is the one that the OFCCP generally focuses on, are systemic cases, and those are also called pattern or practice cases, meaning that there is a pattern or practice of discrimination that extends past 1 or 2 individuals, but stretches really across the organization or stretches across a particular grouping of jobs. Now, the OFCCP also says, however, that it can look at individual cases. So it can do what I sometimes call onesie-twosies and say that in this particular area of 1 to 2, 3, 4 employees, we find that there has been individual disparate treatment or treatment that is different based on looking at what's called cohort comparisons. Now, the OFCCP also says that it's going to have, it also outlines its in particular focuses. So it says that it'll be focusing on inequalities in pay, in monetary compensation, that there will be a focus on unequal training and advancement opportunities. And I think that's a bit of a pivot. Certainly that's been there before. But this focus on training is a little bit different than something that we've seen usually in audits of the past. The OFCCP also says that there will be a focus on assignment and placement differences. That's something that we have seen quite a bit of in the past few years, a focus on not only what people's pay is, but are they placed in the right job? Or are we funneling people to lower paying jobs based on their gender, based on their race, or other protected traits? Another piece of this compensation guidance that we saw was that there may be used anecdotal evidence to support systemic allegations of discrimination, but we're still seeing it's not necessarily required. Why is this important? Well, years ago there was a whole hubbub about the issue of, can you prove discrimination just based on the numbers alone, meaning that there's a gap here and you can't explain the gap without something else, some other evidence, comments, something of that sort which shows anecdotally that people are exercising a discriminatory intent. And this is maybe that's required, but not necessarily. What pay data will be reviewed? Compensation guidance, the fifth directive also explains that. So when you are subject to an audit, many of you all know, you get a letter in the mail called a scheduling letter, which basically says, congratulations, you have been chosen to be audited. And in that letter, there are various numbers of data that must be submitted. Item 19 on that letter is compensation information. So the OFCCP makes clear that the information it's going to review in a pay audit is the data that's submitted, number 19 in the scheduling letter. Now they also put out in this compensation guidance a bit of a procedure which I think will be helpful to federal contractors. So the OFCCP says that if the data submitted as part of number 19 of the scheduling letter is incomplete, the OFCCP must notify the contractor within 7 days and ask for any additional information that it needs. The OFCCP is also told that they can ask for more data after they become familiar with the compensation structure and policies. But I think it is helpful and part of the goal of the OFCCP to move these audits along is to say right off the bat, within a week, if you haven't submitted everything you're supposed to submit under item 19, they need to come to you right away and let you know. Of course, got that out, that if they need more, they can always ask, but this still does have the goal of moving audits forward more quickly. What the OFCCP says that they will also be looking at is how you structure your jobs and how compensation is based on the structure of your jobs. They'll be looking at what your EEO-1 categories are for jobs, what your AAP job groups are, and also other ways to combine jobs to determine what is similar. A key part of any compensation review comes down to this question: what jobs are alike? Because when we are looking at comparing people's pay, we first need to know what is our comparison basis. What are the jobs that we are going to look at and say these are alike? So if there are differences between different races or different genders, these jobs are similar enough that we can really make that comparison. And this has been one of the crucial issues that the OFCCP and really all pay litigation that companies, employees, the government, litigators have struggled with the answer to. What jobs are alike? So this compensation guidance says this about the issue. It says the OFCCP will identify similarly situated employees. Well, that's a very common term. That's the term that's used under federal laws when we talk about who can be compared. But they go a little deeper. And they say that who is similarly situated are those that we would expect to be paid the same based on job similarity, so what they do in that job, the tasks, skills, the complexity, and other objective factors like what the qualifications are for the job, including certifications and education. Now, the OFCCP also says that from there they are going to develop pay analysis groupings. Some of you all that have been around in this OFCCP world before will remember our friend, the previous acronym, SSEG, Similarly Situated Employee Groupings. Now we've got PAGs, Pay Analysis Groupings. What's the difference between a PAG and an SSEG? From a legal perspective and a technical perspective, similarly situated employee groupings were really focusing on more jobs that were similarly situated, and using that term was important because that is a legal term that is rooted in federal law and has a lot of case law in it. By moving away from that and now using pay analysis groupings, the OFCCP says we're now not looking at necessarily similarly situated, but comparable employees. That's a big difference because comparable is broader under the legal term of arts than similarly situated. So now the OFCCP says it's going to look at comparable employees. Now that can be from multiple job titles. It doesn't just have to be one job title, different units, different categories. And the OFCCP says it wants each PAG to contain at least 30 employees. That number is familiar. That was kind of the same as what they said under SSEG. And they say that they'll statistically control for differences. What's important here to get as a federal contractor is that this does broaden how we think of what can be combined. Now we're talking about comparable employees, and I believe that that step away from the term similarly situated was deliberate to have really a broader understanding of who we group and who we compare as federal contractors. So how's the OFCCP going to analyze your data? Yes.
Shafeeqa, sorry to interrupt you. There's a question, and unless you want to answer that at late stage, it says, what if there is not 30 employees in the group to make regression analysis work?
Yeah, that's a great question. If there are not 30 employees to make it work, and regression models by their nature are limited. And they are limited really because they typically only work for large sample sizes. So if they've kind of given us a cutoff basically. And their cutoff is 30. Statisticians sometimes have different cutoffs, but 30 is a fair cutoff of when a regression analysis really makes sense. So what do we do if the sample size is not big enough to do a regression analysis? Well, the OFCCP does not provide us an answer to that. That's the short answer. But it doesn't mean that they give up and there's nothing to do. What's in this directive quite clearly is that the OFCCP can also bring more like individual claims for discrimination. So if we don't have a regression analysis, which is typically tied to a systemic case, then we're looking at more of an individual case, and you do typically what's called a cohort analysis. That means we're kind of going back to the more simplified, I suppose, in a way, looking at maybe 10 people in a job title or job group and saying, looking at their experience and their education and their time at the company and other factors to affect pay, does this make sense, or are we paying people in an inappropriate way? So that's basically what they will go to, but typically what they are doing in these cases is they are looking for the large-scale systemic cases where they can run a regression analysis. But great question. We don't just leave those alone. We would do a separate type of analysis for those. So how's the OFCCP going to analyze our pay? They're going to look at base pay, and then what we're seeing is then they are doing another analysis for total compensation. I would say, a few years back, as OFCCP was getting its feet under them on comp, we could expect that they were just looking at base pay, and for the most part, weren't looking at a whole lot of other things. I think that's beginning to change. Slowly, most are still looking at base pay, but they are beginning to analyze other things, including bonus. So do take a look at your total comp. I think that can be important as the OFCCP gets more refined in its compensation analysis. Things like bonus, commission, overtime, shift differentials, they're asking for all of that, and I believe increasingly reviewing it. Now, what about performance review results? How about that? What I will say about that is the OFCCP says that they will take a look at them, but sometimes they believe that they can be tainted. So if you are submitting performance review results, be careful that you have run an analysis on those to make sure that the performance review results in and of themselves do not look like there's adverse impact there, meaning that it doesn't look like people of different races and people of different genders are being scored lower. Then that's not going to help you in improving pay. They're going to say that variable is tainted, and you've now opened a whole another door for the OFCCP to look at. So do run that analysis first. So what if the OFCCP finds problems with your compensation? Well, back to our first directive, they say that they'll issue a PDN, that's that preliminary determination notice. They'll provide the contractors with the data necessary to replicate the regression results. Huge, huge thing. This is an area that was of much frustration to contractors for a long time, is that they didn't get the data, didn't understand what the OFCCP was doing to come up with these results. Now we've got it in this directive that we are required, OFCCP is required to give us that data so that we can replicate and we can see what they've done. You'll also be given an opportunity to rebut. If you cannot, they will issue an NOV and a conciliation agreement seeking back pay benefits interest for the affected class. And they do note debarment is highly unlikely as a remedy, but always still out there. Another piece of this compensation guidance is it does say that the regulations require contractors to perform an in-depth analysis of all their employment processes, including compensation, to ensure non-discrimination. The FAQs in them suggest that self-audits should be performed with reports to management. Now, what's required under the regulations is that you do review your compensation and all of your employment procedures for non-discrimination. There's certainly no requirement to do any type of regression analysis or report that out management. I will say that that is a best practice, so nothing wrong with putting that there, but it's not something that was strictly required under regulations to do a regression analysis. But you do want to see exactly what the OFCCP is doing, so it's a practice to do so where you have enough data. Another thing to keep in mind, what this compensation guidance does say in terms of grouping, and particularly when we think of that pay analysis grouping, that comparable jobs as opposed to the similarly situated jobs, is that the OFCCP can and will, from what we have seen, group your affirmative action plan job groups and say that is your PAG. So do review and think about revising if you see adverse impact on AAP job groups, exactly how that looks from a comp perspective. You'll want to keep as much compensation data electronically as you can. That's going to help you explain any type of disparities that you do see. As I mentioned, there's nothing in the regulations that requires a particular form of analysis, although you are required to do a proactive analysis every year. Now, as many of you all know, pay is a hot area. It's not just the OFCCP, but there are certainly various enforcement efforts from the EEOC, state laws abounding, as well as federal laws like Title VII and equal pay litigation that you need to keep up to date with and be aware of, in addition to what we've just discussed from the affirmative action standpoint. Well, we're not done with all of our various directives that are out there, so let's keep charging through it. So the sixth one that's come out in 2018 is the Contractor Recognition Program. This says that the OFCCP has in its plans to develop a program to recognize innovative contractors. This is similar to past efforts where various contractors have been given recognition based on their areas, including in areas such as outreach. The carrot at the end of this is that if you receive this type of recognition, then you have a moratorium on audits. We expect that there could be an initiative around this for DOL apprenticeship programs, which have gotten a lot of interest in current administration. Directive number 7. This is a very interesting one. And this is with regards to AAP verification. Now, the OFCCP has said it's concerned. There's a lot of contractors out there that aren't doing their affirmative action plan every year. And so what they are doing, they say that they're going to develop a process where every year you're going to have to annually certify that you have done your affirmative action plan. They are looking to develop some sort of technology that's going to collect and facilitate a quick review of your AAP, where they can conduct a compliance check to verify that you've done your affirmative action plan, and a quick check to see perhaps who they will audit based on some preliminary data. They haven't provided much further information about how this will work, what that information is, and what you're going to be submitting. But the fact that this is put out there as a directive of what they are interested in, I think is very informative and something that we will certainly keep you all up to date on. Directive number 8. This is really trying to address the concern that a lot of federal contractors had that these audits just take too long. And so this puts into play some transparency around what the timeline should be. So first and foremost, the extensions have now been cut back. And so what the OFCCP says is it's only going to grant extensions in the most extraordinary of circumstances. But typically, you get that scheduling letter, and within 30 days, you've got to send it in. Now, here's a nice little caveat, and I have already used it myself for a client, and it is very helpful, which is you can get a 30-day extension of the support data. So if you submit everything, the narratives, etc., you can ask, if you submit that on time, you can ask for 30-day extension on the support data. And that can be really helpful because that's a lot of your numbers. Now you're going to already have to submit your job group, so that will have to be formed, but that 30 days can help. A notice to show cause can be issued immediately if your AAP is not submitted timely. So again, this is all to keep that process moving. And the goal is to close desk audit in a record 45 days. Also directed to compliance officers is that they must limit data requests before concluding the desk audit, and that after the desk audit, supplemental requests must include why they're asking for it, why it's reasonably tailored to areas of concern, and give you a reasonable time to respond. They're also required to tell you preliminary indicators of discrimination, provide you status updates, and collaborate. Remember, all this is going to some of the complaints that were out there, and what's wonderful about this is a directive that you can use with the compliance officer if you are having trouble to say that I am allowed to get updates, understand, and collaborate with you. So, although it's not 2019 yet, we have already had some directives ready to go for the new year. And here is what they are. First, and this is just kind of a house cleaning one, this is a 2019 one. It rescinds a directive that was issued in 2011. Now that directive was really on active case enforcement and went through how long reviews should take and various procedures. Well, that's really been covered by all of these directives that we have now, and there's some differences in timeline. And so this one is just to kind of clean house, and it says we are getting rid of Directive 2011-1 because we've now got our new procedures from 2018. Now, here is one with a little bit more meat on the bones. This is an early resolution procedure that has been outlined by the OFCCP. And what it says is that for non-material violations, these are things that are really technical issues, that those can be corrected immediately during the desk audit. It can be things like you are missing a piece of the affirmative action plan. And if there's nothing else that indicates discrimination or lack of good faith, then the OFCCP will just tell you this is what's happened, provide you compliance assistance, and they will issue a closure letter. Now, for material violations, where there are multiple establishments, the OFCCP, but there's not discrimination, the OFCCP also will move through an early resolution process with you to try to find ways to resolve this, including a way to review your remaining establishment for similar violations. Now this can be record-keeping violations, failure to do applicant tracking, implement an audit and reporting system, and what they would do is work with you to figure out some sort of procedure to put that into place throughout several different establishments, then get a conciliation agreement. But they try to do that pretty quickly. Now they've also got in place material violations that are discrimination. And here's how they have explained how this process will work to try to quickly resolve these types of issues. The OFCCP has said that within 14 calendar days of completing the desk audit, that the compliance officer will tell you that we have found potential discrimination and we want to start the early resolution process. They will talk with you about scheduling essential interviews with appropriate company employees, applicants, and human resources, and try to quickly do that as well as gather electronic information. They will try to expedite that so that they can, after getting all that data, give you a refined analysis within 14 calendar days. And then after that, within 14 calendar days, discuss their findings, a proposed remedy, and corrective actions. And what they also say is they give a timeline of within no more than 60 days from beginning of this process of having the refined analysis to you and talking about a proposed remedy, it will be closed. So what is all this about? It's really trying to move these audits through, responding to the complaints of super long audits. Here what we have is a process as to how to do this quickly and early in the process. Final directive that has been issued in advance of 2019 is that the OFCCP says it's going to develop a searchable, anonymous, publicly available source of questions federal contractors submit and that are answered, and that there will also be opinion letters that are issued that you can take a look at and that you can use. And if you rely on those, that will be looked at if you're found to be in violation in an audit. The OFCCP has also published its audit methodology. As many of you all know, they're also publishing who will be scheduled for audit. And so that's something you can find, and I've listed it right here where you can find it. They've also got a memorandum of understanding with the National ILG and compliance guides now for colleges and universities, they say, are forthcoming. So what does all this mean for you all out there? Well, I really think it means that there are really and the goal is to have audits that are quicker, that close faster, and faster response time. And that means that the OFCCP may not do all the deep dives that they've been doing. Now, the OFCCP's bread and butter is still discrimination. Hiring and compensation is what we can expect for them to look at. When it comes to compensation, know your data and know it well. Look at your AAP job groups. That's how the OFCCP is increasingly focusing on data. Understand that white males can also be victims of discrimination. There's certainly quite a few conciliation cases that are brought on that basis. Fix pay equity problems for one protected group could lead to problems for another group, so think about that and conduct all your analysis under privilege. So do we think we're going to have friendlier OFCCP interactions, more consistency? I believe that that's what's behind this, and the jury's still out on what we'll see in those areas. For sure, we're going to have emphasis on disabled and veteran issues. That's certainly been a focus of Acting Director Craig Lean. I think another thing is we're seeing more and more transparency. That is certainly a good sign. Will Craig Lean be the new director? Time will only tell, but I think that there are good indications on that. What we have seen is it definitely has been a wild ride with lots of things going on, so stay tuned and really keep close to all these issues. I think with that, we have a few moments for a few questions.
Yeah, hi, Shafeeqa. There is a question if we can cover. It says, how does the changing of job groups, etc., affect the prior year goals to progress and review? I actually accepted it. You can see it.
Great question, right? So certainly when you change your job groups from one year to another, then that is going to affect how you are going to report how if you met the goals. I would say, from the perspective of what will matter in an audit, I think that if you have issues in your AAP job group, more important to focus on that from a compensation perspective than how it can affect those job groups. Although an important one, since we've seen the OFCCP focus very heavily on compensation and focus very heavily on AAP job groups as a methodology for grouping, then that's something to take a look at. But you might have to switch around a bit how you report out your prior year goals if you do change those AAP groups.
Great. There is one more question, and this is, when is AAP verification likely to launch? I just accepted it, you can say.
Yeah, great question. And hard to answer, I would say, but I think no time soon. That's going to require quite a bit behind it in order to get it started. Now, there is something already in the law, so they don't believe that they'll need legal changes, which they think provides justification for doing this, but they will have to submit it through various pieces of government in order to make it go through. And there's also a technology factor, in addition to figuring out what exactly makes sense to submit. So I think that is a long-term future goal, but they have put out there that it is a goal indeed. So probably no time soon.
Great. So thank you. It's 3 o'clock. So thank you, Shafeeqa, for a wonderful, very informative presentation. I think we need to do this multiple times, but you really covered it well. And thanks to everyone, for attending the webinar. We will continue to do this, occasionally. Please stay tuned for our next webinar in January. We could not take all the questions, so please feel free to send more questions directly to Shafeeqa or to me. I would forward them. So finally, happy holidays. Our best wishes to you and yours for a healthy, happy, and prosperous 2019. Thank you. And that concludes our webinar today.
Thanks to everyone.